Welcome to this special ILEDA Learning Lab podcast. The Learning Lab is one of the ongoing professional development benefits for members of ILEDA, the International Law Enforcement Educators and Trainers Association. ILEDA is an organization dedicated to advancing the law enforcement profession through the development of trainers and educators and the sharing of information, research, strategies, principles, and concepts related to effective teaching and learning. The Learning Lab currently contains over 150 interviews with ILEDA members on a wide range of topics related to advancing law enforcement training. In an effort to share the experience and knowledge of ILEDA members with everyone in the law enforcement training community, we are publicly releasing some of these interviews in a bi-weekly podcast. After listening to this interview, we encourage you to go to ILETA.org, that's ILEETA.org, and find out how you can become a part of this community of trainers dedicated to serving the heroic men and women of the law enforcement profession by investing in their professional development in order to provide the best possible training. Please enjoy this interview and feel free to contact us at info@ileta.org if you have any questions. I'm Brian Willis, the Deputy Executive Director for ILEDA and your host for the ILEDA Learning Lab. And today's interview is with Graham Tinius, and we are talking about top 10 case laws every field training officer should know. Graham is an officer with the Sandy Police Department in Utah. He has 18 years of law enforcement experience, most of it in field training. He is an executive board member of the National Association of Field Training Officers. Since 2006, Graham has written and taught numerous classes, including adult learning, leadership, motivation and influence, and basic and advanced FTO schools, as well as audited and rewritten FTO programs and policies for agencies across the country and the globe. So, Graham, welcome to the ILEDA Learning Lab.
Thank you for having me.
Now, in your class description, it says most officers know how to read Miranda rights, recognize what a stop and frisk is, and know that an anonymous tip needs just a little bit more credibility to be viable. But if they need to defend their actions or their trainees, can they directly relate what occurred to a specific case law to make their case defensible? This class delves into court decisions that affect daily patrol activities, discusses key components, and lists more recent decisions influenced by landmark cases. We'll examine resources for finding briefs and consider the value of reading the dissent as well as majority opinions. So this is such a critical topic, as you say. A lot of people, we know the frameworks, but we don't necessarily have a knowledge of the case law decisions or some of the things that drive our behavior. So what would be some of those key case law decisions that you're going to talk about that people need to know?
Well, I think starting off, we delve into one of the most basic and most important cases that I think, which is Graham versus Connor, that is reviewed for all uses of force. That's one that we talk about. A newer one that I added recently that I think is a landmark decision that's changing the way everything is being handled is Arizona versus Gant. And then I apologize. And then Rodriguez versus the United States. Sorry, I got those names confused for a second. But I think those three are ones that are changing the way that we're doing business on a day-to-day basis and ones that officers need to be familiar with.
So let's start with Graham versus Connor. And what are some of the key factors out of Graham versus Connor, key elements that people need to really understand?
Well, the whole class that I wrote, actually this presentation started as an article that I wrote for Caliber Press several years back. I was writing articles for them, and most of those articles started over dinner conversations with a friend and mentor of mine. And one night we were talking about how officers get themselves into trouble by doing good things at work and doing things correctly at work, but then documenting them so poorly that when they're examined, it's difficult to justify what you did. And a lot of those are uses of force out of Graham versus Connor. And officers generally understand their agency's use of force policy or their use of force continuum if they still have that. But they didn't understand that all of that was born from Graham versus Connor and the three prongs that Graham versus Connor talks about. So if you asked an officer why they used force, they would use just generic terms. They'd use broad phrases and broad brushstroke kind of answers to that, when you could very simply address the three factors of Graham versus Connor, which is the severity of the crime that was suspected, asking if the suspect posed an immediate threat to the officers or to other people, and asking if the suspect is actively resisting or attempting to escape. And if you framed your use of force report and you framed your police report around those three questions, you could easily justify the use of force that was justified in that case, rather than using broad descriptive terms or just talking about behavior that was observed.
And as part of this, that these things are covered sometimes in silos, where there may be a class on legal issues where Graham versus Connor is covered, and they talk about those prongs. But there's another class around report writing, and it doesn't link these two together to say, hey, this is a framework for you being able to articulate the reasonableness of your actions.
Yeah, I think that's absolutely correct. I think our report writing classes frequently focus on covering probable cause and reducing liability to the organization and proper grammar and English and things like that. But we don't always bring our use of force personnel into the report writing class, and we don't always bring our legal advisor into the report writing class. And I think we fail to remember that, generally I think we write our reports for ourselves so that when we go to court, we have something to refresh our memory so that we can testify on it. But we forget that if this if this case becomes a landmark court decision, then that report is going to be what stands throughout history. That's what people are going to be looking at. How did the officer write the report? What's in the report? Because if you start testifying to things that aren't in your report, issues arise there. And so I think that's an excellent point, that if you can apply a specific circumstance that you're involved in to a court decision, and you can use language from that case law in your report, it bolsters that report and it makes it more easily defensible.
Now, I guess there's a couple of other elements on that. One, going back to the silo effect, it seems to me that there's use of force instructors have some responsibility in this, and again, that they don't necessarily link this or link the articulation in scenarios or in other elements to these key cases. And then do we also is that a mistake to write the report for ourselves rather than realize all the other people that are going to read this report that are going to be impacted by the detail that's in there?
Yeah, I think that is a mistake. And even though this is more of a case law class, most of my history is in field training. And so a lot of my conversations revert back to field training. But I'll parallel this conversation with another one, which is observation reports for trainees. A lot of times I think FTOs write those observation reports for the trainee, for the supervisor, but they forget the number of entities that are going to end up getting their hands on those. And same thing is true with police reports. You have your chain of command and records is going to review it. You have prosecuting and defense attorneys and interns that are reviewing it. If it is some kind of case that's going south, you could have civil attorneys reviewing it. The media can get their hands on it. And it can end up being reviewed by a lot more people than maybe you initially imagined. And so I personally think that a good report will keep you out of court. And some people like that overtime, but I like to stay at home with my family if I can. So I think that if you write a solid police report from the beginning, there's less opportunity for a defense attorney to challenge something that happened there. And that's one of the things that I discuss in my class is writing a solid case report based off of case law in the beginning so that no one can question what happened.
Now, is the other element of this, if when we're using this to as a reference when we're on the stand, that if we've written it in a format that addresses the same framework that the court is going to evaluate the reasonableness of their actions, that we will probably tend to articulate that information in that way, and it will help the court to better understand why what we did was reasonable?
Yes, I think I'd agree with that, but I would even say that if you do that correctly, it might even prevent that from ever getting to court. You know, a prosecutor will look at it and go, okay, well, this is obviously the officer made the correct decision, and a defense attorney will look at it and go, well, there's not much room for us here to argue anything because everything was done correctly based off of existing case law.
Excellent. Great point that if we can stay out of court on some of these, then it allows us to enjoy what free time we do have better. So, a lot of people have heard of Graham versus Connor. Talk about Arizona versus Gant. What are some of the key elements of that case?
Yeah, so Arizona Gant is a newer one, and I just should have started off probably at the very beginning by pointing out that I'm not an attorney. I haven't gone to law school. I'm just kind of a nerd. I'm a geek who likes to read. I'm the guy who actually gets excited for legal update classes. I enjoy reading new statutes. I enjoy reading case laws. And one of the things that I really like about that is going through, and we'll probably talk about this a little bit later, but going through and reading the majority decision, but also reading the dissent and finding out what a judge perhaps didn't like about the police officer's actions or reports or the state's actions. And kind of getting some takeaways from that. So it's just reading case law is just kind of something I do. I think it makes me a better officer. I think it makes me a better trainer. It keeps me kind of updated on the leading edge of how things are changing in my department and across the country. So I just want to point out that I'm not an attorney. I'm not a legal advisor. I don't have a formal education in this. This is just something I do for a hobby. But Rodriguez versus the United States, came out of Arizona, out of Tucson. When I first became a cop in 2004, we would arrest someone in a vehicle, and then we would search their car. And that was probably written into policy, if I'm not mistaken. If it wasn't written into policy, it was definitely practice. If you arrested somebody in a car, you searched the car. And it didn't matter what you arrested them for. So you'd pull somebody over for a suspended license. And in Arizona, that was a physical arrest case if you wanted it to be. You put them in cuffs and put them in your car, and then you'd toss the car. And if you found drugs or paraphernalia or something like that, then that was an additional charge. And we did that pretty consistently. And that was probably not the right thing to do. And I didn't realize it at the time because that's how I was trained and that's what common practice was. But thinking about how the Constitution is framed and what that means, it probably wasn't the correct thing to do. And in Rodriguez versus the United States, and I'm ad-libbing from memory here, but they were looking for Rodriguez for a warrant. And they were sitting on his car waiting for him, and they saw him get into the car and pull out, and officers pulled him over. And they arrested him on the warrant, and then they searched his car and they found some cocaine. And his argument was, if you're arresting me out of the car, why are you searching my car? And our answer is always, well, search incident to arrest. And of course, and I'm sorry, I may have just messed this up. It was Arizona versus Gant, correct?
Yeah, we can talk about Rodriguez or Arizona versus Gant, whichever.
And Brian, I'm sorry. I hope you can edit this afterwards because I just got my titles mixed up in front of me here. So
that's okay.
Everything I was talking about was Arizona versus Gant.
Okay, that's fine.
So he says, what were you searching for? And in search incident to arrest, what are we trying to do? Well, we're trying to prevent injury to the officer by discovering weapons, or we're trying to prevent destruction or loss of evidence. And so the officer's arguments were, well, we arrested you out of the car, so we were searching for evidence or weapons. And Gant basically says, well, the crime was a warrant, so, what was it that you were looking for? If you knew who I was and you had identified me already, what other proof did you need that this warrant existed? And the court listened to that, and they basically agreed. And so that fundamentally changed the way that we did our job. And that meant that you could no longer search a vehicle after an arrest, just incident to arrest, unless you had arrested for a specific crime and you were looking for additional evidence from that crime.
So, in Arizona versus Gant, it was they searched the car, they arrested him for a warrant, they searched the car, they found dope, and he said, hey, that search had nothing to do with the arrest, had nothing to do with the warrant, and the court ruled that search then was unlawful. What about officers that say, well, you know what, we're going to tow the car because we're not just going to leave it here where it was, and so we need to inventory the car? Is that a part of this or addressed in this, or is that one of those old school things that the courts are saying no?
So inventories are still lawful, and there's logic behind it. You don't want somebody coming back and alleging that a valuable item was taken from their car by the tow yard. You also don't want to have a tow yard take custody of a car with dangerous or illegal materials in it. But I like the way that you said, we need to take this car, so we're going to inventory. What I hear far too frequently is officers saying, well, we need to do an inventory search. And I strongly discourage officers from using inventory and search in the same sentence, because a search should be the state seeking out evidence, and an inventory should be just that. It should be a list of materials that are inside the car. And with that, I also urge officers, if they inventory your vehicle, do a good inventory every single time. Because if you inventory a car that you're not interested in and you write, nothing of value or nothing of value, or you just write down, 2 CDs or something like that. But then the one time that you're inventorying a vehicle and you do discover drugs, or you do discover a weapon that was used in a crime, and now suddenly you're very detailed in your list, it's very obvious that you're using that inventory as a search tool. So do a good job consistently. And consistency is a very important topic in police work and in report writing. But do a good job consistently. And if you're searching or you're inventorying a vehicle from an accident, and there's clothing and there's tools in it, just write everything down. Be detailed every single time so that it doesn't look like you're using an inventory to bypass the Constitution.
Now, in Arizona versus Gant, did they identify when it would be appropriate for officers to conduct a search of the vehicle?
So I don't know that I have a specific answer to that. Okay. I will tell you that we, of course, still have the vehicle exception. We can still do searches incident to arrest. You can still do probable cause searches. So if you're arresting somebody for drugs, I feel strongly that you can still search that car for drugs and paraphernalia if you have reason to believe that they're in there. If you have reason to believe that a suspect is armed and you pull them out of the car, you can search that vehicle for a weapon. Now, things change when you start. Again, we have to go back to, why are we searching the car? What is the exception that we're using? And that is search incident to arrest. And why are we searching for weapons search incident to arrest? And that is to avoid injury to the officer during the arrest process. So if you have a suspect and you have 6 officers on scene, and you take that suspect and you put him in a squad car that's 5 cars back, handcuffed and locked in there, you're losing your justification, right? Because it's hard to say, well, I had to recover that gun from that car because I thought the suspect might get access to it and kill me, if he's handcuffed in a car 4 cars back with 6 other officers standing around.
Excellent. So, and it seems to me that this is the importance of your class and understanding some of these case law decisions, that there's a lot of things we do just, well, that's the way we do things, or that's the way we've always done it. But if we don't understand what the law allows us to do, then we can get ourselves jammed up or compromise perhaps evidence that was seized. Is that one of the keys with this as well?
Yeah, I think so. I think a lot of times we are doing things because that's the way it has been done. And of course, case law changes the way things have been done. That's the courts telling us, you did it this way up till now, and from this point forward, you can't do it that way anymore. And that's why I know that a lot of people don't like legal update classes, and some people find them quite boring. But not every case is a landmark decision. Not everything is as big as Miranda versus Arizona. There are some cases that aren't that big that are still telling us that we need to change the way that we do business. So it's important to pay attention to those.
Absolutely. So before we get into, so we've talked about Graham versus Connor. We talked about Arizona versus Gant. Before we get into Rodriguez versus the United States, you had mentioned a couple times about that it's important to read the dissenting opinions of the court, not just the majority decision. Can you talk about the importance of reading both of those and why we should be reading the dissent when sometimes we probably would have a tendency to skip that?
Yeah, absolutely. And in fact, what I'll do is let's redirect instead of Rodriguez versus the United States, we're talking about Illinois versus Wardlow. And in Illinois versus Wardlow, you basically had some Chicago police officers that were in a high crime area, known for narcotics trafficking and known for people carrying weapons and known for a lot of crime going on. And when they come around the corner, they see a guy holding a bag, and he sees the officers and he turns and he immediately runs. And so the question is unprovoked flight or evasion alone reasonable suspicion for a stop? If you turn the corner and somebody looks at you, you turn the corner at work and somebody looks at you and they turn and they run, is that reasonable suspicion to chase and stop them? And Illinois versus Wardlow basically answered that question. And so the answer is, in a vacuum, flight alone with nothing else is not enough. Location alone is not enough. And holding an opaque bag is not enough. However, when you add together the location, the time of day, the fact that it's a high crime area, holding an opaque bag, and the fact that he fled when he saw the officers, together, the court said that nervous, evasive behavior is a pertinent factor in determining a reasonable suspicion. This is a case I want to talk about because it was a 5-4 decision out of a 9-person panel. So you can see how close we were to losing this case. And one of the things that the court said in this is that they were not going to enact what they call a per se rule, which is a bright line rule, which is something cops love, right? Because it basically says, if you're on this side of the line, you're doing your job correctly. If you do this behavior, you're doing your job incorrectly. And they said very clearly, we're not going to give you a bright line rule. We can't tell you when unprovoked flight is going to be reasonable suspicion. But what you need to do is justify your actions. So if you, for instance, pulled up to a convenience store and somebody was standing outside of the convenience store and they saw your squad car and immediately ducked into the convenience store, that's not going to be enough for the stop. So this is one of those cases where officers need to understand the totality of the circumstances. Writing a report isn't always super black and white. It's not always just, one factor that you need to talk about. Sometimes you need to write your police report like you're telling a story, like a really exciting story where you want a lot of buildup and you want like a nice apex to bring this story together. So you need to talk about all these different aspects that are coming together in order to make that case solid and to come full circle.
Now, totality of circumstances, it's interesting that you use that phrase because I wrote it down as you were talking. It seems to me that we use that term when we talk about use of force. But again, it seems to me that that's not something that we teach people on how to tell a story and how to encompass all of that totality of circumstances. Is that one of the keys as well with all of this, is that we need to learn to tell stories effectively?
Yeah, I think it is. I don't think a lot of cases are cut and dry. And I had a call that I was on myself recently where we were flagged down by a convenience store clerk, and they pointed out that there was a woman in a car outside, and she appeared to be going in and out of consciousness. She had been out there for quite a while. It was pretty warm out, and he was concerned for her well-being. So we walk up to the car, and one of the things that I tried to do in my head is always gauge where we're at. Consent, reasonable suspicion, or probable cause. That's it. Every contact that you have as a police officer on duty, falls under consent, reasonable suspicion, or probable cause. Like there is no fourth option. And so I constantly play this game in my head where are we right now? And if somebody says, am I free to leave? Do I know the answer to that question? So we walk up and we're not quite at reasonable suspicion, but we're looking at more of like a medical welfare check. So I walk up and I talk to her, and she says that her car overheated and she's sitting here and she can't get water from the 7-Eleven because of COVID-19. They won't let her bring her own container in, but she doesn't want to spend money on a bottle of water because she's almost broke. And while I'm standing there, my partner's looking in the back of the car, and he points out that he can see some needles. And so that changes things a little bit. So I keep talking to her, and I point out the needles to her, and she says, oh, I think they're clean. And she picks them up, and they look clean. And so, of course, clean needles, not inherently unlawful. But now that you've got somebody with needles who appears to be going in and out of consciousness in the parking lot of a convenience store, I'm like starting to build up this reasonable suspicion. And as I'm talking to her, I run her for warrants, and I'm allowed to do that. And I'm waiting for that information to come back. And she starts fishing around in her pants, like her hands digging in her pants all of a sudden. And then it goes in between her seat and her console. And now I'm trying to figure out, is she trying to get something, or is she trying to get rid of something? Is it a weapon? Is it drugs? What's going on? So now, like, we're definitely beyond reasonable suspicion altogether. And I'm ordering her out of the car, and she's not listening to me, and her hands are continuing to go under the seat. And I'm ordering out of the car again, and she gets out, and it turns out she had some kind of a taser device, and she thought it might have been illegal, and she's panicking. And so based off of all of that, I felt that I had a right to frisk the car, which is also something some officers don't know that you can do. You can frisk a vehicle, but I'm frisking the car to find out if she was trying to conceal a weapon under there, because at this point she still has some access to the car, even though I'm on scene there. And as I'm going in the car to find out if there's a gun or what she was hiding, she tells me, oh, there's a meth pipe in the car too. So now I'm a probable cause, right? So like this is the story that's building up in my head and how it's going. Well, at some point during the contact, initially we had asked if she minded if we searched the car. Right after if she had any drugs, she said no. And we said, can we search your car? And she said, yeah, I don't care. That all happened before these events. And so after everything was said and done, we got some paraphernalia and stuff out of the car. And I was talking to my partner that was on scene with me and said, hey, trying to make sure that like sequence of events are the same for both of our reports, that you have the same understanding I do of how we got in the car. And he said, yeah, consent. And I was like, wait, no, not consent. Like, I don't agree with that. Like, here's how I see it. And I kind of laid the story out for him and built the story up and said, this leads to this, leads to this. And I think there was a question about like, well, as soon as we saw the needles, we were good to go. And I pointed out that clean needles are not inherently unlawful, but everything together, once we build all these building blocks together, I felt we had reasonable suspicion to enter the car. And so that's a long-winded answer and a story for how I think you can take case law and change it into training too. Because it's one thing to sit down with a 12-page case law review and hand it to your trainee and say, hey, this is about searching vehicles, incident to arrest. It's another to go out and have that experience and go through that investigation and then take a step back as an FTO and say, okay, how did we get into that car? And your trainee says, oh, well, she gave us consent at one point. And then you point out that through everything else that happened, that consent didn't matter anymore because she was suddenly in custody. But in fact, the way that you got into that car was by starting with a welfare check. So you had a reason to contact her, and then observing the needles and talking about the needles and finding out that they were clean, but she's possibly on the nod and she's like at the south end of this convenience store and she didn't really have a necessary reason for being there. And then she's suddenly evasive and she's trying to conceal stuff, and building that all up builds your case. And that makes the totality of the circumstances is what justifies your search. But then relating that story to your trainee or to your fellow officer makes them understand better and retain better what that what that all built up to and how to apply that in the future.
Absolutely. And it seems to me that rather than the longer-winded answer that provides a totality of circumstances, is that we're in the habit of shortcutting our answers, both verbally, and we're in the habit of shortcutting what we put in the report. And some of us grew up in an era where we were told the less is better, which is not good advice, and that we need to learn the art of storytelling in report form so that we can build the case and link it to these case law decisions. Is that accurate?
Yeah, I think a lot of times we try to take the easy way out, and I don't mean to make that. It sounds like we're lazy, and I don't think that's what it is. But I think a lot of times we just think to ourselves like, oh, well, if there's an easy answer, why not go with the easy answer? But a lot of times the difficult answer or the difficult explanation can be more solid. And so when I wrote this case, when I wrote this class, it was sort of flexible because I've taught it at a variety of different conferences where I have different time constraints. And it also depends on how much class participation and conversation happens, because some people really like to hash things out and some students just like to listen. But a part of this class that I put on the tail end, and if I have time at ILETA, I'll go through it, is the 17 exceptions to the search warrant requirement. And I transition into this here because you talk about taking the easy way out. And a lot of times I find that officers will enter a house or enter a yard, and you'll ask them, well, why did you enter? And they'll say exigency. You're like, yeah, that's great. Like, which one? Specifically, what exigent circumstance did you use? Well, I had exigency. I had exigency to go in. That is a easy blanket answer that doesn't really tell us anything. And I don't even know how many officers know or don't know that there are only 17 exceptions to the search warrant requirement. 4 of them are like administrative and don't apply to law enforcement, but there's 13 exceptions that law enforcement can use to search outside of the Fourth Amendment. And that's where I try to get people, if they're entering a house because of community caretaking or because they're needing to offer emergency aid, that's what I want my trainee to write in their report. You know, we entered the yard or we entered the residence based off of this exigency, and that's why we had the justification to be in there. And it's more difficult. It's more difficult to apply what you're doing to a very specific circumstance, but that's the right way to do it. And that's what's going to prevent you from getting in trouble.
Absolutely. And it seems to me that exigent circumstances is one of those things, like I did it for officer safety reasons or for their safety in mind. It's just something that we say because we've always said it, or that's what was said in training, and we don't necessarily understand the justification behind it. So did you want to talk about some of those other 13 exemptions to the search warrant requirement, or did you want to jump back and talk about Rodriguez versus the United States?
Well, I'll leave the rest of the requirements as a teaser for the class if people are interested. But I just think it's important for people to know that there are only 13, and they're all specifically written down, and they're accessible. And you should know them, and your legal advisor should know them. And if you are a supervisor or a trainer, you should definitely know them. And that's how you should refer to things in your report rather than just saying exigency. It's exactly like you said. We talk about doing things for officer or safety reasons, or we talk about furtive movements or things like that when it comes to doing a Terry stop. So we can transition back here into Terry versus Ohio, which is one of the cases that are in here. And I think a lot of people hear Terry versus Ohio, and it's such an old case that people almost roll their eyes, you know, like, well, like you don't need to know it because it's so old. Everybody understands it already. But just like the exigent circumstances, you should have like a checklist for making reasonable suspicion to make a frisk. You should have a checklist for reasonable suspicion to make a forcible stop. You know, those are things that we shouldn't just make up on the fly. At no point should you say, I saw this person and I had reasonable suspicion to detain him, and I went up and I patted him down. That's not like that to me is not good enough for a report. So there are agencies out there that will give literature to their officers that has things written down. Like, here are things that you want to consider if you want to frisk someone. Here are things you want to consider if you want to make a forcible stop. And if you're writing your report, you should reference back to that sheet. Well, I mean, honestly, you should know that sheet and have it memorized so you can do your job correctly. But when you're writing your report, refer back to it and list those specific things out in your report so that they're there and available so people understand what your reasonable suspicion is. Because we don't just have reasonable suspicion. It's not the hair on the back of your neck standing up. Even though we'd probably like to think it is, especially if we're experienced officers, we'd like to think that we have that sixth sense, but that in and of itself is not enough to make legal decisions. You have to back it up. And I think we throw out things like officer safety, reasonable suspicion, furtive movement, exigency. We throw those out like blanket statements, and that just doesn't cut it.
Absolutely, and it's interesting you brought up Terry versus Ohio because, again, being a Canadian, we're not ingrained in these case law decisions. But I know when you talk about things like Terry frisks, and it comes up sometimes in some of the training that I do because it's see officers do it in a video, and so you ask people, well, what is your justification for doing that? And what I hear an awful lot is, well, for officer safety, which is not the legal standard. Can you talk about the legal standard for a Terry frisk?
Yeah, so, I mean, Terry gives an officer the ability to perform a search for weapons with only reasonable suspicion, not probable cause. But it's when the officer reasonably believes that the person may be armed and dangerous. And I think that is, as old as this case law is, I think that's something that a lot of people don't realize, is that the person has to be suspected of being armed and dangerous. So if you contact a person at night in a high crime area, you can't just pat them down because they exist there. You have to justify why you think that they were armed and why you think that they were dangerous. And those are two separate concepts. So we can't just pat people down because we're looking for drugs. We can't pat people down because we're looking for paraphernalia or money or stolen property or anything like that. We only pat people down to determine if they have a weapon and if they're dangerous.
Now, is there a requirement there to have a suspicion that they have committed a crime, or is the criteria that we have a reasonable suspicion that they're armed and dangerous?
So what I'm familiar with is the suspicion that they are armed and dangerous, not that they are in the process of committing or having committed a crime.
Excellent. Now, so what about Rodriguez versus the United States? What are some of the keys from that case?
So Rodriguez versus the United States is one of the newer cases, and it's probably the one that I'm probably least familiar with out of all the ones that I talk about. I'm still reading about it. I'm still learning about it. And when I talk about these things, I like to bounce them off of legal advisors or attorneys that I know, and I haven't had as much of an opportunity with Rodriguez as I have with some of the other cases. But Rodriguez basically says that absent reasonable suspicion, you can't extend a traffic stop in order to conduct a drug sniff. So we all know that in the past, what we would do is either make a traffic stop for a traffic violation because that's what it is, or you make a pretext traffic stop because you suspect drugs. And then while you're waiting, you call for a canine, and that canine's on the opposite side of town. And so he takes 35 minutes to drive over there. And so you start filling out the ticket and you engage in some conversation with the driver, and you sit in your car and you wait. And when the canine shows up, you do an exterior sniff and the dog hits, and then you get Philp out of the car. Well, in Rodriguez, they basically determined that if you stop a car for an expired license plate, then you have exactly as long as it takes to investigate and take enforcement action on that expired license plate. And then the second that you are done with that, you are finished, and you cannot detain that driver any longer, absent outside reasonable suspicion of another crime being committed.
Excellent. So it doesn't preclude the having a canine do the drug sniff. It's just that you can't extend the traffic stop and stall and delay to facilitate that. If the canine happens to be parked behind you while you're filling out that traffic ticket, then that's still reasonable.
Yeah. So if and here's where we need to be consistent in what we do. So if you can pull somebody over and knock out a traffic ticket in 6 minutes, that might be really great if you're a motor officer and that's all you're doing all day is writing traffic tickets. But that's not going to be helpful for you as an investigative tool. And the court didn't come out and say that you have exactly 20 minutes and 22 seconds or anything like that. But what we're going to do is look at how long your traffic stops usually take and how long does it usually take you to write a ticket. And with most officers now carrying a body cam, I don't know which case this was. I just saw it in a legal brief, but you had lawyers arguing seconds in a call, that, at this point, the officer walked up and handed him a ticket. And then, 7 seconds later, he's asking him about this other incident that occurred. So with body cams being recording, defense attorneys are going to look at that. And if you're in your car and you're supposed to be writing a ticket and you're updating your Facebook status or you're, just looking at your CAD screen and flipping through different tabs, I think a defense attorney is going to ask if you were unlawfully delaying that traffic stop in order to give a canine time to get there. So I think the moral of the story there is to keep your traffic stops consistent. They should all take approximately the same amount of time. If you're pulling over a Sunday driver for going 15 miles under the speed limit and you're just writing them a ticket, or you're pulling over somebody that you think is leaving a drug house for a broken taillight, those traffic stops should take the same amount of time. The second thing is that if you have any reason to think that you're going to need a canine or additional resources, you're going to want to call those as soon as you know and express the urgency and them getting there efficiently. And then the third thing is that you want to be working on the traffic stop and the enforcement the entire time that you're on that traffic stop so that none of your actions can be second guessed as delay tactics.
Excellent. And again, in today's world, so much is recorded on in-car cameras, body cameras, computers, and other elements that that consistency is absolutely critical. So what would be one or two of the other cases that you would talk about and share and have a discussion about in your class?
Well, one that I really enjoy is Florida versus Bostic. And I think it's interesting because it's actually, in my opinion, like very pro-officer, very pro-cop. And I think the court's decision on that and some of the phrasing that they use in their decision is really interesting. And basically what happened is Broward County Police Department randomly checks passengers on buses to stop drug trafficking. And so what they would do is they would get on buses and they would look for people that looked nervous, or look for people that looked out of place, and then they would ask if they could do a consent search of their luggage. And of course, we know, like with consent, people can say no, but some people did say yes, and in fact, Mr. Bostic said yes. So they went on the bus and they saw him. They asked him, "Hey, can we search your luggage?" And he said yes. And when they opened it, they found a bunch of cocaine and they seized that. And Bostic basically came back and said that he was unlawfully detained and that the consent wasn't valid because he was being detained on the bus. And his argument was that and I can't remember the specific time, but let's say that the bus left at 1:00, the search was happening at 12:30. And if he wasn't free to leave the bus, because if he left the bus, he would have missed the bus. And without being able to leave the bus, he didn't feel like he was free to deny the search from the police officers who were confronting him on the bus. And so the question was, does a seizure occur simply because a police officer approaches an individual and asks a few questions? And we all know what consent stops are. And we know that we have to be careful in how we phrase things. If you tell someone to come here, that's different than saying, "Hey, do you mind if I ask you a few questions?" One of those is an order and one of them is a question. So one of them, is not consent and one of them is consent. And the court said that a reasonable person would feel free to disregard the police and go about his or her business, and the encounter is consensual and no reasonable suspicion is required. So they said that even though these officers were getting on the bus to talk to people, it was still a consent stop because a reasonable person would feel free just to tell the police, no, thank you, I'm not interested, and go about their business. And Bostic, basically, his claim was, well, I was on this bus, and if I had gotten off the bus, I would have missed it. And so that was a seizure. And the court said the mere fact that Bostic did not feel free to leave the bus doesn't mean that it was a seizure. And his freedom of movement was restricted by a factor independent of police conduct, which was him being a passenger on the bus. And so the court's argument was that the bus is not a government, the bus schedule is not the police. And so they are not keeping him. And the fact that he decided to stay on that bus and consent to the search was entirely his independent decision.
Excellent. Now, these would be Greyhound buses or that type of bus traveling from one city to another, as opposed to
I imagine
public transit?
Yeah, that's correct. Like a long haul. So this was probably going, if he's bringing cocaine, probably from Florida, he's probably going up to New York or Chicago or somewhere like that. I don't know if the case specifically talked about where he was headed.
Excellent. So Florida versus Bostic. What would one other case be that you think is critical for officers to understand, or is there any other elements of Florida versus Bostic that you wanted to share?
No, I'll switch to a different one. And what I like is Pennsylvania versus Mims, another one that I think officers know, and that is the ability to order a driver out of their vehicle. And again, I think a lot of times, I don't know if a lot of times, but I imagine that some people hear this and they're like, oh, Pennsylvania versus Mims, everybody knows that. Like, why is this one important? And that's because I find that sometimes officers will get caught up in a little bit of contempt of cop, and that will affect their stress level, which starts affecting their decision making. So you go up and you have a driver who refuses to roll down their window completely. They crack it a half inch and they hang their driver's license out there. Or you walk up and the driver has their music turned up very, very loud, or they're smoking and the cigarette's right in your face. So my question is on a traffic stop, do you have the right to order someone to turn off their radio? And I'll usually have somebody say yes. And when I ask why, they'll say because it's an officer safety issue, which you and I already discussed the lack of detail in that. Or I'll say, can you order someone to roll their window down? Somebody will say yes. And again, it's usually an officer safety issue, right? But my argument is forget about the radio, forget about the window. You have the legal right to order them out of their car. So why worry about something that you can't control, like the volume of the radio, when there is something that you can control, which is whether or not the driver's in the car? So if you have an uncooperative driver who doesn't want to roll down the window, or who has their stereo on, they're smoking, or they have other people in the car that are interfering with your investigation, the easiest thing that you can do is just use Pennsylvania versus Mims, order them out of the car, and conduct your traffic stop at their trunk or on the hood of your car or wherever. And so this is kind of a smaller argument for knowing case law intimately so that you can keep the most amount of control at a scene by doing what is easiest and simplest for you. Instead of getting into a back and forth argument at the window, just yank them out of the car. Just pull them out of the car. You're well within your right to do that. And then that puts you back in control of the situation.
So in Pennsylvania versus Mims, does it provide some parameters that in these parameters that you can order the driver out of the car, or is it that as long as the stop is lawful, then the police officer can order the driver out of the car?
Yeah, that's correct. As long as the stop's lawful, you can order the driver out of the car. I mean, there's so many factors to officer safety at a traffic stop. And I mean, one of the factors of officer safety is that it's not just the driver of the vehicle that you have to watch out for, it's traffic around you, right? So if you're engaged in an argument with somebody, you're not paying attention necessarily to what's going around you, and it puts you at a greater danger. So it's basically carte blanche under Pennsylvania versus Mims. You can pull a driver out of the car if that's what you need to do to get your traffic stop completed.
Now, does that apply to passengers as well, or strictly to the driver?
So Pennsylvania versus Mims applies strictly to the driver, but then I pose the question, what about passengers? And then that falls under Marlin versus Wilson. And I don't talk about that in my class, but I tell people, if you want to know the answer to that question, go read Marlin versus Wilson, and you'll find out whether or not you can take passengers out of the car.
Now, when you say pull a driver out of a car, does Pennsylvania versus Mims give the officer the ability to forcibly remove the driver if they refuse to get out?
So I don't want to say that the law specific, like I don't believe that the judges said if they refuse to get out, you can force them out. But, under your department's use of force policy, Pennsylvania versus Mims gives you the legal right to have a driver step out of their vehicle. And so failure to do so, in my opinion, and in my experience, allows you at some point to use that level of force to remove the driver from the vehicle if they refuse.
Right. And again, I would go back to articulation of totality of circumstances. Now, and this may be something, or probably something that you are not going to cover in your class. But what about the reverse of that? Are you aware of case law decision that allows officers to tell somebody to get back in their car? Because this becomes an issue. I think the other issue is, number one, getting them out, or the other issue is they get out and you want them back in their car.
Yep, and I wouldn't know the name of a case right off the top of my head. I'm confident that on a traffic stop that you are allowed to control the driver's movements for their safety walking in traffic and for your safety having to conduct that business. And this is, again, where I urge people to do their own research into case law and talk to their legal advisors. But yes, I would say that you are well within your right to direct somebody to get back into their vehicle to control their movements on a stop.
So talk a little bit about people doing that research. If people are used to just getting the updates when they're given an in-service training or sent out through their department, and not in the habit of going and doing the searches themselves and looking for some of these briefs, what advice do you have for people on the best way to do some of that if they want to start doing more research on their own to gain a more in-depth knowledge?
Yeah, absolutely. When I first put this class together, one of the other reasons was that as an FTO instructor, we teach FTOs across the country, we get questions frequently about like, oh, well, what are some case laws that FTOs need to talk about? Like, let's talk about FTO-specific case law, thinking that there were going to be these very important cases out there. And so I started researching that, and I found out that most of the cases fall into three categories. And it's so if you search like field training officer in case law, it's somebody being sued by a citizen, and that person happens to be a field training officer. Has nothing to do with the case, but that's just part of their credentials. The second one is somebody who was applying to be a field training officer, and they were denied that position, and so that officer is suing their agency. And then the third one is somebody who was terminated as a probationary release, who's suing to get their job reinstated or to be compensated. And none of those were like really important. None of them like really screamed out to me like this is something that FTOs need to know. But where I was searching for those, to come back to your question, was scholar.google.com. It's basically a case law database. And so you go to scholar.google and you can put in any kind of search parameters that you want. You can put in excessive force, Fourth Amendment. You can use keywords like I search officer in training. I search field training officer. I search FTO, different things like that. And then you can filter those searches out by date. And that's kind of a good place to start. Beyond that, there is law.justitia.com and there's caselaw.findlaw.com. And I find those two are a little bit easier to use if you already know the case name. And if you search that, they do a good job of kind of breaking down like a little summary and giving you a little bit more layman's terms. Whereas what you get on Google is just, it's the report from the court. The other two websites give you a little bit more of a layman's term breakdown of those.
So when they do the Google search, it's important to put the scholar in front of the Google rather than just doing a Google search?
That's correct. Yeah. So if you put the scholar in front of it, it will bring you to a website. It's called Google Scholar. And you can look up articles or you can research case law. There's two different tabs there. And of course, the articles are going to be like scientific articles, scientific papers. So if that's a hobby of yours, you can also look those things up. But if you click on case law, then it will only search case law for you, and you can filter those out. And then once you do that, you can actually search by federal court, you can search by state court, you can search by circuit court if you're looking for something specific. One of the challenges of teaching this class across the country is that these are not all United States Supreme Court decisions. Some of them are lower court decisions, and so that changes things slightly. So if you are more interested in cases that are happening in your part of the country, you can search for specific courts.
Now, I'm assuming it's important that after officers or trainers read through these a number of times and work through some of that on their own, then they would sit down with somebody else, a legal advisor or somebody else, and bounce some of these things back and forth and say, this is what I understand from what the court said. Is that an accurate interpretation? Is that an important piece of this as well, that rather than me just reading it and without the legal education making my own assumptions, is it important for me to sit down and talk to somebody who might have that background?
Yeah, absolutely. You always want your agency to back any decisions that you're going to be making. I was really lucky at my last agency in Arizona. We had a fantastic legal advisor, had a great relationship with him, and I could walk into his office at any time and say, hey, I found this, and this is how I'm reading it, and this is how I'm understanding it. He was also a brilliant, brilliant guy and was usually 12 steps ahead of me anyway. And so anytime I brought something into his office, he already knew what I was talking about. But it's good to have that. You can also talk to your city prosecutor. If you have a city prosecutor, you can talk to your municipality's legal advisor. You can talk to the city attorney, whatever it is. But yeah, I urge people, read it first, try to make sense of it, try to understand it correctly, but then seek out an attorney and make sure that your interpretation is correct.
Excellent. And there are a number of attorneys that are members of ILETA that teach at the conference, so it's also a great opportunity to pick some of their brains or attend some of their classes and have a deeper discussion. So a lot of great information. Graham, now if people want to reach out to you to find out more about the training that you offer, the FTO training and some of the other training that you do, what's the best way for people to reach out and connect with you?
Yeah, so I'm the National Training Coordinator for the National Association of Field Training Officers. I'm also one of their instructors. So we provide all kinds of FTO training, leadership and instructor development, and we go in and help people evaluate their FTO program, kind of audit it and provide recommendations and updates and things like that. We offer some classes that we have already, like Basics FTO and a class called Beyond the Basics of FTO. And then we've also built custom classes for agencies depending on what they need. So my email address through there is training@nafto.org, which is NAFTO, stands for the National Association of Field Training Officers. So training@nafto.org. They can reach me there.
Excellent. Now, the other question that we're asking everybody in Season 3 of the ILETA Learning Lab is, what is one piece of advice that you received or a concept or philosophy that you were exposed to in your career as a trainer that helped you to become a better trainer?
Oh, that's a good question. I think the biggest thing that changed me as a trainer was understanding that training is not about the trainer, it's about the trainee. And that is true in an FTO car, and that is true in a lecture and a classroom setting. And I think frequently we walk into training and we get the first 20 minutes is this long built up resume about the instructor and everything that they've done. And then that instructor teaches however they've always taught that material. I think what changed me and improved me the most as an instructor was sitting down and taking the beginning of a class or the beginning of an FTO period and asking the student or the students, tell me about yourself. So in an FTO car, and it's, hey, what's your background? Where do you come from? What's your life experience? Do you have previous law enforcement experience or not? Are you 21 years old and fresh out of college? Are you 40 years old and retired from another agency? Is it a small agency, a large agency? And in a class, especially in our FTO classes, we start every class with, what's your biggest gripe or concern about your FTO program right now? What gives you the most amount of anxiety or headaches? Because there's no point in me teaching an 8-hour class about how to write better reports if everyone's reports are great, but the problem is actually communication amongst the peers. And so I think the best thing that we can do as instructors is understand who our students are and understand what our students want and how our students want to be taught, and then teaching them that way.
Excellent, and such great advice for all trainers, and important for all of us to remember that it's not about us. So thank you, Graham, for making the time for the interview. But more importantly, thank you for your commitment to this profession over the last 2 decades, and for all the important work that you do in the area of field training officers. Field training officers are some of the most important and most influential trainers in our profession, and often some of the most underappreciated trainers and leaders in our profession. So for everything that you have done, everything that you continue to do to enhance our profession, thank you so much for your service.
And thank you, Brian, for everything that you do with ILETA and introducing me to ILETA and other people there. And I've built such great relationships, and I feel like I have improved as an instructor and as a trainer through the connections I've made there. And I appreciate all of your hard work as well.
Well, thank you for that, Graham. And also thank you to the listeners. Thank you for being an ILETA member and for being a trainer. As a trainer, you are in one of the most influential leadership positions in this profession. Being a good trainer is a lot of work, and I thank you for making that commitment. I encourage you to let the information that Graham shared with you in this interview simmer, percolate overnight, and then be intentional about sitting down tomorrow, writing out your greatest takeaways, and writing out your action steps. What actions are you going to take to do further research, to look up some of these cases he discussed, or to go and look up other cases, or to do a deeper dive into some of this information. Thank you for taking the time to listen to this interview. I trust that you found value in the information shared during the interview. To join the community of thousands of trainers who are committed to advancing law enforcement training and get full access to all the benefits of being an ILETA member, go to ILETA.org, that's ILEETA.org, and click on the members link, then on the membership application. If you have 3 or more trainers in your training cadre, then please consider contacting our Director of Operations, Jenny Merlin, at jmerlin, that's JMERLIN, at ILETA.org for information on bundle memberships.